Thanks, Aoife. Yeah, I have been, I was checking my phone there to make sure that nothing had happened in the hour since I sat down. I'll put my phone down for timing purposes, actually. Apparently it hasn't, but I can't promise that I won't be overtaken by events in the next 20 minutes. So I'm going to talk, slight change from billing in the programme, but I'm going to talk about Brexit, where are we now, and what could it mean for fishing legislation. So Article 50 is all the rage at the moment. I'm going to endeavour to explain what it actually means. I'm going to try not to get into the politics of it, but I'm more just going to try and explain the legal framework within which the politics are happening. If you don't necessarily consider yourself enlightened by the end of my talk, you will hopefully at least be confused in new and more interesting ways. And then I'll say a few words about some of the key legal consequences for fishing. Some of that will just be highlighting the mechanisms by which some of the changes that you've already heard about will be made. Article 50 is the provision of the Treaty on European Union that allows a member state to leave. Just to recap, you may have checked this out a couple of years ago and then assumed you wouldn't need to look back to it again. What we're looking at the moment is the process under Article 50, paragraph 2, which says that a member state that's withdrawing negotiates and concludes an agreement with the European Union, with the remaining member states, setting out the arrangements for its withdrawal, taking account of the framework for its future relationship with the Union. So that is the process that we are currently stuck in. The most recent development in respect to that process is the extension of the deadline, and the mechanism for that is in Article 50, paragraph 3, which says that the default position is that the treaties, meaning the EU treaties, shall cease to apply to the exiting state, so that's the UK, from the date of entry into force of the withdrawal agreement, or failing that 2 years after the notification given in paragraph 2. So that means that you can have a withdrawal agreement that specifies an earlier exit date, but if you don't have a withdrawal agreement at all, then the default is that the state leaves after 2 years from when it gave its notice. UK gave its notice 29th of March 2017, which is how we got to the 29th of March 2019. Unless, you can see the final sentence, the European Council, in agreement with the member state concerned, unanimously decides to extend this period. And that is what has happened. This is in fact what was expected to happen rather than what has happened. This was produced by this image was produced by the EU back in I think early 2018. This was how they expected the process to go. By March 2018 they would have a first draft of a withdrawal agreement agreed between the EU and UK. There would then be a tidying up period. Stock taking I think possibly means the EU's summer holidays. Then by October 2018 there would be a final withdrawal agreement. Now in fact we got to a final withdrawal agreement, or what we thought was a final withdrawal agreement, by the end of November. But ever since we've then been stuck in the light blue box, which refers to the Council concluding the agreement after the European Parliament has consented to it and the UK has ratified it. The problem we have is that the UK can't ratify it because it turns out the UK government negotiated a deal that it did not have a mandate to negotiate from the House of Commons, which has to approve it. So we've basically been stuck in that deal, and the rest of the time period has just been compressing around that. So delay or no delay is my first question. Where are we with that? The UK government requested a delay to the 30th of June under Article 50, paragraph 3. But you'll recall that any delay has to be agreed unanimously. So the EU didn't agree to that. It offered an extension only to the 22nd of May if the House of Commons accepts a withdrawal agreement, or the withdrawal agreement, or otherwise to the 12th of April. So it's basically a 2-week extension unless the House of Commons agrees to the withdrawal agreement. And then on Friday, the UK government wrote to the EU to accept that offer, which I put a question mark against this, but I think that should be sufficient for Article 50 purposes. So as far as the EU is concerned, the UK is not going to leave on the 29th of March. But there is still although this will hopefully be resolved, if not today, then tomorrow, there is a potential for a bit of a banana skin in all of that, in that the European Union Withdrawal Act, which legislated for Brexit, says that exit day is the 29th of March. The government can change that date by order, but it needs Parliament's consent to do so. Now, you would think that given Parliament voted in favour or voted against no deal and in favour of the government going off to seek an extension, that wouldn't be a problem. But there are lots of things you would think would have happened in the process that have not. So we have at least the possibility that Parliament might refuse to consent to the terms of extension on offer. If that consent is refused, then exit day in the legislation won't change, and that will have various legal consequences, including requiring government departments and other government bodies to publish various things and do various things on or by the 29th of March. But as far as the EU is concerned, and as far as EU law is concerned, as I said, the EU will still consider the UK to be a member state, which means the EU law will still apply. And because the Withdrawal Act, the provision that would repeal European Communities Act 1972, which is the basis for EU law applying in the UK, the Withdrawal Act would repeal that on exit day, but that provision is not in force, so we can get to exit day and that act won't be repealed. And if you don't repeal that act, then EU law still has direct effect in UK law and will trump any provision of UK law that is incompatible with EU law. So that is a very convoluted way of saying that whatever happens in Parliament, EU law is going to continue to apply in the UK until the 12th of April. The only question is whether it does so in a messy way or a not messy way. The next question then is deal or no deal. So what happens if the withdrawal agreement, for all its travails, is nevertheless approved? So if that is approved by the House of Commons and it's finalised, the UK would formally leave the EU, presumably on the 22nd of May, because that's what the EU's extension provided for. And that's because the EU wants the UK out before the European Parliament elections on the 23rd of May. But with a withdrawal agreement, there would then be a more or less standstill type transition or implementation period until the end of 2020. The reason why there would need to be an extension until the 22nd of May if the withdrawal agreement is approved is that there would need to be UK legislation to give effect to the withdrawal agreement. So it's not just a case of the House of Commons votes for it and then that's it, done. That's my next slide. The other alternative, a further postponement of withdrawal, so with or without a finalised withdrawal agreement, the parties could agree to extend the Article 50 period again to whatever date they agree to. But as before, all EU member states have to agree to that, and the UK has to agree to it as well. So the UK can't impose an extension on the EU, and the EU can't impose an extension on the UK. If there's no deal, means we don't have a withdrawal agreement and there's no agreement on an extension. The UK could leave the EU on the revised date of the 12th of April. That would mean there's no transition or implementation period, and that is what has now become known as a hard Brexit. The term hard Brexit has taken on many different meanings over the past 3 years, but that's currently what we mean by a hard Brexit. And then the fourth possibility is no Brexit at all. So the European Court of Justice did confirm last year that the UK could unilaterally revoke the Article 50 notice without requiring any consent from the rest of the EU, and in that case would just remain in the EU on existing terms. Curious thing about the Court of Justice's decision there is it seemed to rule out the possibility of a tactical revocation, so revoking the Article 50 notice just in order to start the process all over again, submit a new notice and get yourself another 2 years. In that circumstance, I suspect the Court of Justice would say that the second notice was not valid, so anybody who's thinking that that would be a good tactical wheeze would be taking quite a big risk. So I mentioned that there would need to be legislation. This is the process for getting the withdrawal agreement implemented on the UK side. The Commons needs to approve any deal reached with the EU before the UK government can legally ratify that deal. So usually the UK government has the power to enter into treaties at the level of international law. But what this requirement does, and it's set out in the Withdrawal Act 2018, it says that it basically disapplies the UK government's power to ratify any deal with the EU unless the House of Commons has voted in favour of it. So that's why it's referred to as a meaningful vote of the Commons. It's not just indicative. Any attempt by the UK government to ratify the deal without Commons approval would be illegal and would be struck down by the courts. So if you can get to that, there's still then further procedures that have to be gone through. If the Commons approves it, you still have to legislate for the withdrawal agreement to have effect in UK law. And the mechanism for that would be the European Union Withdrawal Agreement Bill, which the UK government has prepared but has not published. So if there is a meaningful vote in favour of the withdrawal agreement, probably looks unlikely, but there are more informed speculators than I about that. Even if it gets the withdrawal agreement approved by the Commons and the Lords would still have to get the legislation through to implement it. And there may be nasties hidden away in that bill that people who would be unhappy with them have not yet seen and which might yet cause difficulties. So getting it through the Commons is not by no means the sort of last word that Parliament would have on the matter. I referred to the Constitutional Reform and Governance Act 2010. That was a piece of legislation that said that Parliament has to approve essentially any treaty that the UK is going to enter into. So that does apply over and above everything else that I've been talking about. They might just fold that into the withdrawal agreement bill, or it might be yet another hoop that has to be jumped through. And then there is just simply the physical process of ratification, which is actually something that it's an action that has to be taken. It means that paper copies of a treaty have to be physically signed. They then have to be deposited with a repository in Switzerland that's going to hold the treaty, and until it's deposited it doesn't actually take effect. So that's why you need extra time beyond just getting a meaningful vote, because there are things that simply have to be done. If the withdrawal agreement is approved, I thought I'd say something quickly about fisheries under the backstop. So the backstop is what happens if you get to the end of the transition period, the end of 2020, without having agreed a new trade deal to well, not to replace it, to take effect at the end of the transition period. So under the backstop, the UK would no longer be part of the common fisheries policy. The key point of the backstop is that there would be a single customs territory with the EU that would cover the whole of the UK. So the UK, Great Britain and Northern Ireland would be in this single customs territory with the EU, which would generally allow goods to move tariff-free, even if not quite free of regulatory constraints. But the free movement of fishery and aquaculture products would not automatically be included in the backstop, other than for Northern Ireland, unless an agreement on access to waters and fishing opportunities is applicable between the Union and the United Kingdom. So fisheries from Great Britain would actually fall outside the backstop unless there is an agreement on fishing waters reached by the end of 2020. And in that case, fish landed in Northern Ireland could move into the EU tariff-free, but fish landed in Great Britain could not. And the intention set out in the withdrawal agreement and the associated political statements is that any agreement on fisheries should be negotiated as part of the future relationship and within the context of the overall economic partnership, meaning part of the future trade relationship, which perhaps optimistically the documents say could be expected by the 1st of July 2020, based on current speed of progress. That is perhaps over-optimistic. So that's what would happen under a withdrawal agreement. In terms of a no-deal situation, the UK government has issued various documents, guidance documents, called technical notices, also other guidance documents that are sector specific. There's the European Union Withdrawal Act 2018, which I've mentioned as giving effect to Brexit. What it also does is incorporates EU law into domestic UK law and allows the government, both the UK government and devolved governments, to make legislation that fixes that legislation so it makes sense with the UK being outside the EU. The more policy-heavy changes have had their own legislation, so you can see some examples on there, and there is some Brexit-related legislation that's still going through Parliament and is not likely to conclude in the next few weeks, such as the trade bill, so there may actually be gaps in the sort of policy sphere, but the orders made under the Withdrawal Act should at least fix EU law so that it still works outside Brexit. And on the EU side, the EU has issued its own what it calls preparedness notices about what would happen for UK businesses looking to do business in the EU. I'm going to say something briefly about people, but I'm going to be very quick about that because I know Darren Stevenson is discussing it tomorrow. Irish citizens, if you are Irish or you have Irish citizens in your workforce, they don't need to worry about any of this. Irish citizens are unaffected either way by Brexit. The withdrawal agreement provides for free movement during the transition period to the end of 2020, and any EU citizen who's residing in the UK before the end of that period will be able to remain after, and similarly UK residing in the EU. The UK government's opened what it calls a settlement scheme, which allows EU citizens to apply for settled status if they've been here for 5 years, or pre-settled status if they haven't yet been here for 5 years, either of which lets them stay. Deadline for application, middle of June 2021. If you have people in your workforce who are wondering about this, the key message is that they have an automatic entitlement to stay, but they have to apply. So they're entitled to it automatically, but it's not conferred on them automatically. There is a public pilot scheme at the moment which is supposed to open fully at the weekend. The government was going to charge a fee for that, but has waived that. Under a no deal, it's a very similar principle, just with different deadlines. So the free movement would end as things currently stand on the 12th of April, but EU citizens resident in the UK before then would still be able to stay under the settlement, the settled status scheme, although with a different deadline for application. And then after or into January 2021, there would be a new skills-based immigration system, which I won't spend any time on today. So in terms of fishing-specific information that's been published, some of the guidance papers and reports that have been put out by the UK government. So there's a guidance paper on fishing and the marketing of seafood if there's no Brexit deal. So that includes issues like rules for access to waters, access to ports, quota allocations, importing and exporting, and labelling and marketing. Then the second guidance paper there, last updated earlier this month, that applies to wild-caught marine fish only, and it covers things like catch certificates, export health certificates, landing documents, storage documents, processing statements. Can I ask by a show of hands, has anybody actually read either of those documents? A few. Good. Trade associations and other sort of industry organisations like Seafish have been pretty good at helping circulate the information, even if their members haven't necessarily read the documents. So you may know what's in them, even if you haven't read them. And on the EU side, there was a fisheries and aquaculture notice issued almost a year ago. In terms of legislation at UK, and this is at UK level, there is the Fisheries Bill, which is currently before the UK Parliament. That's UK legislation, but it is being prepared in conjunction with the Scottish Government. So even though fishing is notionally within the Scottish Parliament's powers, the Fisheries Bill, they're cooperating to have a UK-wide system. Although there are disagreements between the UK and the Scottish Government about particular things being within devolved competence and requiring the consent of the Scottish Parliament. And that includes about the setting of quotas for fish caught in Scottish waters. And you may already know the Scottish Government has launched its own consultation on fisheries management, which is going to run until the 7th of June, and which basically sets out some of their objections to the Fisheries Bill and invites the industry to say, you object to this too, don't you? That's obviously a very reductive explanation of it, but that's an element of it at least. The bill is supported by the Fisheries White Paper from last July, which set out some of the policy aspirations, and the House of Commons has recently issued a report on fisheries and Brexit. So if you're looking for something that's fairly up to date and an explanation of what's happening legislatively, that would be a good starting point. We then have a number of orders that have been made under the Withdrawal Act. So these are the orders that are intended to allow the existing body of EU law to still function within the UK after Brexit. So the first four there, those basically make various, and these are made by the UK government, they make various technical changes to the existing CFP rules. Some of those have been mentioned already. They're not really supposed to be making any policy changes. It's about changing things like who's the responsible authority for a certain matter if it's no longer the European Commission. The main change that's made by a lot of these orders is in relation to EU vessels now being treated in terms of UK waters the same as non-EU vessels. So the current rules that apply to non-EU vessels will be applied to EU vessels. And similarly, the preferential treatment conferred on EU vessels at the moment will be restricted to UK registered vessels under these changes. The final point there, state aid for agriculture and fisheries. Agriculture and fisheries. They have their own state aid rules. The policy there isn't really changing, but the Competition and Markets Authority will take over responsibility for that from the European Commission. Then some more technical orders there that affect fishing but are not specific to fishing, the first three. The fourth one, Seafish licensing regulations, that's about the rules on non-UK vessels in English waters having to be licensed. Again, that's just the extension of the current non-EU rules being widened out to include non-UK rules, and the treatment of EU vessels being narrowed down to UK vessels. Then the merchant shipping and fishing vessels, there's loads of shipping orders being made. This is the only one that specifically mentions fishing vessels, basically just making sure the current health and safety rules continue to apply. The Scottish Government has also been making similar legislation. The first few there, they're not competing with the UK changes. They assume that the UK changes are being made and they're designed to work on a complementary basis with them. So they do fit together if you read them very closely. Although if you're not familiar with reading amending legislation, I think they will put you to sleep extremely quickly if you can even concentrate on them long enough for that to happen. You can see the third bullet there, so that's the equivalent licensing regulations in respect of Scotland. So that's what non-UK vessels have to do to access Scottish waters, which is getting a licence from the Scottish Government. The licences and notices order are intended to use vessel licensing as the means of imposing and enforcing conditions on any foreign vessels through domestic law, and to create a level playing field for the foreign and domestic fleets fishing in the Scottish zone. So that's very much a statement of policy, although it's not really supposed to be making substantive policy changes. The official controls charges, again, that amends the regime that currently applies to non-EU vessels so that it applies to non-UK vessels instead. To the extent the EU rules give preferential treatment to EU vessels, then post-Brexit it's only UK vessels that get that preferential treatment. Lastly, just a couple of pieces of guidance and orders that are related to or that have wider application than fishing and seafood, but have some application to them. So there's guidance on health marks on meat, fish and dairy products if there's no Brexit deal, and you can find all these online. They're all on the UK government website. There's also guidance on exporting animals, animal products, fish and fishery products. So obviously fairly general, but you can get information from there that's specific to the sector. I mentioned the exporting and importing fish that is specific to wild-caught marine fish. And then there's general information like prepare your business for the UK leaving the EU, and that's produced by the Food Standards Agency. So there is lots of information out there. There's probably too much information out there. But if you find yourself wondering what to do about a no-deal Brexit situation, these are some of the places you can go. You can also go to the Brodies Brexit Hub, which has lots of information on there about different aspects of Brexit. You can get in touch with me. My contact details are there. You can get other contact details via the hub. And on the hub, you can also find our, I've got a copy with me here, Brexit Are You Ready checklist. So I imagine that, or I would hope that that will be complementary to the seafood guide that Aoife mentioned. This really raises general business issues, so things that are not sector specific. So things like people, contracts, travel, IP, data, regulatory authorities, that sort of thing. So you'll hopefully find it useful. And indeed, I have a stack of them over on the table as well. So if anybody wants to get a copy of that, just come over and see me at the refreshments break. I realise it does mean travelling in the opposite direction to the refreshments, so I apologise for that.
We'll take them with us.
Yeah. So I'm obviously happy to take questions. And indeed, I think we are moving on to session now. Thanks for your time.